Welcome everyone. Today we are fortunate to have Nicholas from TSMP to share more with us about COVID-19 and employment law. The two interviewers today will be myself, Chun-Zing, and Sam. So without further ado, we'll jump right into the interview. And our first question is, Nicholas, could you share with us more about one interesting COVID-19 related employment case that you have come across?
Hi everyone, good to meet all of you. I think there's a couple of cases that I've come across. One of the things that really struck a chord in me is there was this individual, she was quite an elderly woman, around the 62, 64 year range. So the thing is, after you hit 62 in Singapore, you are covered under, with some exceptions, you are covered under the Retirement and Re-employment Act. And you get to have yearly renewals of the contract until you the statutory re-employment age of 67. So what happened to this lady was that her pay got cut by 30%, and the basis that the company put forward is to say that there was COVID-19 related exigencies. They were having a little bit of a cost issue, so they are cutting the people who are on yearly contracts by 30%. But that didn't quite make sense because the people who are on yearly contracts are exactly those between 62 to 67, right? So that it did seem as though there was some age discrimination going on. But ultimately, it shows that, it really lies with the employee on whether or not the employee wants to take action. Because if, let's say, this employee does take action, we are faced with a problem where the employee might not be employed for the next year and cannot generate income for the next year. And instead, what the employee will then get is just a lump sum payment in compensation at best, right? But that's not going to equate to the salary that an employee is going to live with for the next 1 year or 2 years, right? So here, there's a trade-off between do we want to pursue what we think is really right at the expense of having to lose, putting at risk your 1 or 2 year salary. That's something that you see does happen quite a lot. There's a lot of push and pull factors. But I think some of the more interesting cases have actually been reported in the press. One that comes to mind immediately is the Eagle Services Asia case. So that's quite interesting because what happened there is that we had about 144 employees being retrenched. And what happened was that there were 3 unions that were engaged in talks with Eagle Services Asia. But all of a sudden, Eagle Services Asia decided to dismiss the 144 without notice. So some of the accounts, you have a 56-year-old man saying that he didn't even get to say goodbye to his friends. He was just told to pack up and leave. Why this is interesting is because actually the unions were pretty, I would say pretty, I would say they were willing to take steps to protect the employees. So insofar as the Secretary General of NTUC, Ng Chee Meng, he actually authorized the conduct of a secret ballot amongst the union members. And this is something that has never happened in quite some time, I would say. What the secret ballot does is actually it takes into account everybody's views. It's sort of like a mini, it's so secretive, it's sort of like what we see in elections, but a scaled down version of it, but it's very difficult to, administratively at least, it's very difficult to conduct. But what that secret ballot does is that if there's a majority and if there's a certain percentage, then the unionized workers can actually go on strike or take some sort of industrial action. That's something we don't see in Singapore very often. So what happened in this case is that eventually no industrial action needed to be taken, but it shows how far the unions are willing to go to protect the employees, especially the unionized employees. So I think that's pretty encouraging to hear in these uncertain times. I hope I answered the questions.
Yes, you definitely did. I think through the examples that you've brought up, perhaps one issue might also be that of bargaining power, because I guess as an employee, when we are retrenched abruptly, especially, most of us are actually at a loss at what to do. And I think perhaps do you have some tips for employees as to how they should react in such situations? Should they perhaps, sign the letter quickly, or perhaps take some time to actually contemplate on what they should do moving on?
Well, in terms of tips, we want to sit back and we want to first analyze all the documents that have been given to us. Most of the time when you're retrenched, you will be at least given a notice of termination, right? That notice of termination, to be honest, whether you sign it or not, it is effective by itself. It's just giving you a notice. You don't need to sign on it. But the moment you receive that notice, you are terminated. Unless, you can kind of negotiate forward. So take a look at that notice of termination and figure out what it says. What does it give you some sort of like reason for the termination? Bear in mind, employers are not obliged to provide reasons, but if a reason is provided, you want to look into that and you want to ascertain whether that reason is a true reason or if something does not quite accord with reality. So that's the first thing. Of course, you then want to seek legal advice on what exactly your rights are. Or you also might want to approach the union. So as we see in the Eagle Services Asia case, the unions actually can bring quite a lot of pressure in terms of a collective bargaining sense. So going to the unions might be useful as well for help. So I think those are the main starting points.
Okay.
That's about it.
Thank you for the sharing. I think you mentioned on rights earlier, right? So perhaps could you help us to clarify on what exactly are the employer's obligations towards the employees, especially in light of the COVID-19 situation today?
I think that's a pretty wide question. Let's talk about in the context of, let's say, what we see in given the COVID-19 pandemic is there's a lot of cost cutting. There's a couple of retrenchments as well. So let's cover the obligations in relation to these areas.
Yeah.
Now, in terms of cost cutting, right? We have to look at how reasonable the cost cutting is. And ideally, the employer wants to start off with the least severe measure, right? And there are a couple of measures set out in this tripartite guidelines. It's called the Tripartite Advisory for Managing Excess Manpower and Responsible Retrenchment. So that guideline, it actually sets out what are the different types of cost-cutting measures you can take. From the least severe being, consume your annual leave, and the most severe being no pay leave, right? So that's the range that you go from the start. We start with how much leave would you think is reasonable for the employer to ask the employees to take. Then you move down one step. Do you want to reduce the number of work days in the week? That's an example you can take. Do you need a temporary layoff if, for example, your factory has closed down? And then do you want to look at wage cutting? And then do you want to finally look at no pay leave? If all of that really does not work, then the employer will then have to consider retrenchment. But the point is, the employer's responsibility to the employees here is to really go through all of those steps to see whether which is necessary to take and which is perhaps too severe and perhaps too unfair to the employees. That sort of goes into the whole responsibility towards employees in terms of cost cutting. There's also a reporting obligation to the MOM and the Ministry of Manpower. So whenever employees' wages get cut by about 25%, notifications have to go to the MOM within a week. I believe it's a week. If it's not 5 days, it's a week. Essentially about, let me just check that actually.
Yeah, sure.
Notifications should come. Let me just check that, just to make sure I've got the timing correct. Yeah, it should be within a week.
Okay.
So those notifications are important because what MOM has reported is that TAFEP, the Tripartite Alliance for Fair and Progressive Employment Practices, they do intervene if the measure seems to be too severe. And then what has been reported is that TAFEP has intervened about 700 employers as well. So that's a safeguard in a sense where the MOM sort of forms a check and balance against what the employer is doing. So that's cost cutting in general. Now, when it comes to retrenchment, then you will need to first you will again need to go back to the advisory that I mentioned, the tripartite advisory for managing excess manpower and responsible retrenchment. That also lays out a procedure for retrenchment. Broadly speaking, first you got to consider everything, all the cost-cutting measures first. If that's still insufficient, look at retrenchment. Start consulting your unions, right? As we see in the Eagle Services Asia case, the unions can bring quite a lot of pressure and can speak up for the employees. So you have to start the consultation process early. If there are no unions, you will also need to consult the employees. You also need to make sure your selection process is objective. It's not discriminatory. For example, it doesn't discriminate on grounds of race or nationality. So after you've considered all of that, then you can roll out the retrenchment measure. You will have to give proper notice to the employee concerned. Again, here there's one thing that's really important is to really your communication with the employees must be strong. And I suppose that applies to both cost-cutting measures as well as retrenchment. So based on MOM's findings, there have been a lot of cases where the communication was not strong enough, and that resulted in a lot of misunderstanding. So we want to make sure that communication there is strong. So going back to retrenchment, once you've given a notice, if there's a notice period, the employment should come at the end of the notice period. And you also need to go and notify the MOM of a retrenchment exercise. Yeah, so similar things of both kind of exercises, you will need to notify the MOM.
Okay, thank you, Nicholas. So,
yeah.
Just to clarify, there's what is actually like the difference between retrenchment and termination, and how do you think that employees can guard themselves against disguised retrenchments, which allow employers to terminate employment without paying retrenchment benefits?
Yeah, well, the difference between retrenchment and termination, really one is a subset of the other. Termination occurs for whatever reason. It can be a contractual termination, it can be a termination for poor performance or misconduct, or like maybe even a wrongful reason for termination. So termination is a wide spectrum, whereas retrenchment is a type of termination. Now, what exactly constitutes retrenchment is we don't have a legal statutory definition for the word retrenchment, but we do have a couple of reference points. Most recently, our Manpower Minister, Ms. Josephine Teo, she actually said that a termination is going to be presumed to be a retrenchment if the employer cannot show a plan to fill in the vacancy, which makes sense. I think that's the largest. Most categories of retrenchment fall underneath that category. Of course, there are other. If you look beyond what the Manpower Minister said, there's also a set of wrongful dismissal guidelines, and there's also a set that also includes things like restructuring. The MOM website also points towards reorganization as well. So retrenchment does not necessarily need to fall within the category of no replacements, but I think by and large, most of the retrenchments happen where an employee is let go and there's no replacement for the employee. Now, how we protect ourselves against disguised retrenchment. So what exactly is disguised retrenchment? It's really where there is a retrenchment going on, but you cover that retrenchment with other reasons, for example, poor performance, or you give no reason for the retrenchment, no reason for the termination, but you see a lot of people being let go at the same time, and no employees are being employed to fill that vacancy. So these are examples of disguised retrenchment. I think it's possible for people to get quite creative. But again, the idea is you go back to the presumption of retrenchment when there's no plan to fill the vacancy, and that's how you try to identify a disguised retrenchment. You also look at the reasons given in your notice of termination, or if there are no reasons, you look at the surrounding circumstances. How many people have been let go? How sudden was it? Are there any plans to fill the vacancy again? And that's how you identify a disguised retrenchment. How you protect yourself from it? Unfortunately, you can't quite take proactive action to protect yourself from it, because when it comes, then you know it comes. What you can do is for perhaps those workers that can be unionized, you could actually make sure that you're unionized and you're protected by a union who can sort of represent you and collective bargain for you. What you also can do is then seek legal advice after you get the notice of termination, and start to analyze the reasons and the circumstances surrounding your termination. Once you've had a position on whether or not you have been actually retrenched, you start to look at your legal recourse, which might include going to the employment claims tribunals, might include also making whistleblowing reports to the MOM as well.
Yes, thanks for sharing, Nicholas. I'm glad you touched on the legal recourse that will be available to employees. And in particular, you mentioned the Employment Claims Tribunal. Perhaps could you share a little bit about the other legal proceedings that can be taken if employees should seek to take legal action? And also perhaps just a point on how, for Employment Claims Tribunal, the lawyers are not allowed to be present alongside the
that's right.
And how might that affect the entire situation?
Well, I think right now the Employment Claims Tribunal, ever since its inception, it's kind of been geared towards the purpose of it is really to help employees find quick legal redress without having to incur a lot of legal costs. So that's a starting position. That's what the Employment Claims Tribunals are for. I think so. In that sense, it's sort of allowing access to the less able in terms of financially speaking, right? Now I think the Employment Claims Tribunal and most of the courts will have to consider really both parties to the equation. We have here quite a lot of impacted employees, impacted industries. So even though you have been retrenched, right? It's not. And even though the retrenchment might have been not entirely proper in terms of process, that doesn't necessarily mean you have a claim against the employer, or that doesn't necessarily mean that your claim will be made out. You have to start looking at the circumstances of the employer as well as the employee. Now we have some statistics. We have pretty much 45,000 employees affected so far. In terms of the accommodation and food services, we've got 25,000 in construction and 19,000 in wholesale and retail trade. That's based on an MOM press release. I think it was released quite recently, actually. But the fact of the matter is we can't expect over close to 100,000 employees bringing employment claims every time they feel that they have been wronged. You have to start looking at both sides of the equation. Yeah.
But in terms of perhaps legal proceedings, if they wish to commence any formal legal proceedings, perhaps what are some of the salient points that the employees should be aware of?
Okay, so there's a couple of timelines involved. You have, broadly speaking, before the Employment Claims Tribunals, you have two types of claims. One is called the wrongful dismissal claim, and that's for the circumstances surrounding your dismissal. If you feel that that's something that has something's not quite right about it, that's a claim that you can choose to pursue. The other is called the salary-related claim. Now, salary-related can pretty much mean a lot of, it's not only salary, it's not confined to salary. Salary-related claims also include bonuses, include retrenchment benefits, the spectrum of payments. So both of these kinds of claims, they have a set timelines to it. So if you feel like you've been wrongfully dismissed, you have about 1 month from the date of your dismissal to lodge a request for mediation at the Tripartite Alliance for Dispute Management. That's the first step. The mediation requests are always the first step towards Employment Claims Tribunal's claims. You have to go through mediation first. So that's a 1 month timeline for the wrongful dismissal claim. For the salary-related claim, we have 6 months from your dismissal, or 1 year from the dispute, or about 1 year from the dispute occurring. Yeah, so that's sort of the process. You first start with the tripartite mediation. If that fails, or if no suitable solution has been reached, then you start looking towards filing an ECT claim.
Okay, sure.
Thank you. To move this to move this forward a bit. So recently, there's this phenomenon about time banking which is this whole pay now, work later model that is used by employers to cut costs. So as an employment lawyer, what do you think are the rights employees have against employers with regards to time banking, and whether or not do you think that this is considered unfair employment practice?
Time banking is pretty new, I would say. It's a sort of a flexible work arrangement, and that's something that has been sort of approved by the MOM. But the important thing here is that I think here that the problem is how time banking is policed or how time banking is regulated. So if you're, the main statute in Singapore that covers our employment rights is the Employment Act. And part of this Employment Act is Part 4. There's a couple of parts. Part 4 is one that sets out your standard out, your minimum hour, well, I would say your maximum hours of work, your right to rest days, and your right to a set number of overtime payments. But Part 4 only applies to two categories of employees. One is workmen who are being paid $4,500 and below for per month. And then the other category is non-PMEs, non-professionals, managers, employment, and executives earning $2,600 per month or less. So only these two categories of employees are covered by Part 4. Now, under Part 4, what these employees are going to be entitled to are restrictions on not working more than 8 to 9 hours a day, not working more than 6 consecutive hours without rest, not working more than 72 hours in overtime for a month, right? And all of these can be, there are certain situations where these can be exceeded, but that's really when something is urgent or when something is necessary for the national security or some breakdown of a plant or something like that. But by and large, these are the main thresholds that an employer must take care not to breach. Now, when we bring time banking into the picture, and if we are speaking about Part 4 employees, then the employer also needs to make sure that these minimum employment act requirements or thresholds are not breached. And importantly, you are also supposed to apply to the MOM for approval of your time banking arrangement. So that's the regulation around time banking, and that's how time banking can be an effective tool, but it has to be and that's how you guard against errant employers who sort of adopt their own version of time banking and for example, force you to work 5 to 6 hours overtime a day, right? So that's not going maybe 5 to 6 overtime a day for a month. That's clearly going to exceed the 72 hours threshold for monthly overtime work. Now, the other thing is that to bear in mind is that time banking is only more. I would say it's more relevant for people who are entitled to overtime, who are, in a sense, Part 4 employees. Now, if you're beyond Part 4, if you're a professional manager or executive earning more than if you're a professional manager or executive, or if you're a non-PME earning more than 2.6K, then you are not statutorily entitled to overtime. And the concept of time banking doesn't quite help you save the hours, so to speak, or doesn't quite help the employer save the hours. Not as effectively as Part 4 employees, at least.
Thanks, Nicholas, for sharing with us on time banking. There is also another area which is much discussed, and that is the whole idea of working from home and working in the office. Now, with regards to this area, what rights do employees have if the employer insists on making the workers return back to the office instead of working from home, in spite of the fact that they are perfectly capable of doing their work from home?
Right. So I think the starting point is that the MOM guidance has been the work from home should continue to be the default. So if, for example, you have an employer that is insisting that you come to work, you have to start looking at why you're being asked to come back to work. Is it something that is the reason because the job needs you to be in the workplace? For example, if we have some of the financial institutions, they need people manning the counters to service the customers, right? If, for example, there's really no good reason for you to be in the office and you don't need to be in the office, but the employer is still asking you to come back, then you might want to start raising this with your internal management. If that fails, you could potentially feedback that to the MOM, because the MOM is really the one that's starting to, and to be honest, they are quite active. They have been looking into employer workplaces and making sure that everyone working from home is deployed to the extent, to the maximum extent possible.
Okay.
Yeah.
Thanks for sharing with us on this issue. Perhaps just before we conclude the interview, do you have any final thoughts to share with employees and employers on how they can cope in this COVID situation that we face today?
Well, I think it's really it really boils down to give and take. I think the clear guidance from the MOM and from all the multi-ministry task force is really employers and employees have to work together. Employers are definitely feeling some, especially in certain sectors like aviation, like food and beverage, they are feeling a lot of pressure, that they are under a lot of financial pressure. And the employee is there to really, you want to protect your rights, but at the same time, you want to also try to help your employer to tide through this pandemic. We don't know how long it's going to last. So I think both sides really need to be a little bit reasonable. Both sides need to be understanding of each other's position, which is why, again, communication between the employer and employee, it becomes very, very important. Now, if you are served a notice of termination, you might want to start seeking legal advice on it. Again, if it doesn't tally with the situation, if it's a disguised retrenchment and you have reason to believe it's a disguised retrenchment, you can approach your unions. You could approach the MOM as well, or you can also seek a legal advice from a lawyer.
Okay.
Yeah.
Thank you very much, Nicholas, for the sharing so far. We have now come to the end of this particular episode on employment law. If you do have questions about how the COVID-19 situation would affect other areas of law, please do check out the other videos under the COVID series. Thank you.
Thanks very much.
Thank you.